The report says, at the resumed hearing today, that's yesterday, Mazi Nnamdi Kanu said that the court, he said to the court that he has gone through the case file and has realized that there is no valid charge against him. That was Nnamdi Kanu informing the court. That he has opened the files, one after the other, everything filed. The charge preferred against him by the prosecution. He has looked through the evidence and he has come to the irresistible conclusion that there is no valid charge against him. He went on. He argued that since he is convinced, personally convinced, that there is no valid charge against him and that he was subjected to unlawful trial, note, unlawful trial, there would not be need for him to open his defense. That's what Nnamdi Kanu told the court. He has gone through the case file. He has seen that there is no valid charge against him. And that since he has gone through the file, he has seen that his trial was unlawful, he doesn't want to enter his defense. There's nothing to defend, according to Nnamdi Kanu. The report then says, Justice James Onmotosho, that's the presiding judge, asked him to file a written address to that effect and to serve a copy of it on the prosecution, which is the normal thing to do in law, right? When you file, you serve it on the other party because it must be on notice so that the other party can also respond. The judge advised him to consult experts in criminal law on the consequences of the option he has chosen. The judge took out time to talk yesterday in court that he should consult legal experts in criminal law to brief him about the consequences of the option he has chosen. What is the option? Not to defend. Because Nnamdi says there is no valid charge against him. The judge thereafter adjourned the matter till 4-5-6 November. That's a few days from now, right? This is October ending, for the adoption of the final written address. That means the judge has given him less than 2 weeks, less than 14 days, or less than 10 days or thereabout, to file the final written address based on the defendant's position that evidence led so far and the charge have not established any case against him. Right? Now, this is Nnamdi Kanu, We asked some questions. What is the legal implication of what transpired in courts yesterday? What is the legal implication? The answer is that, one, it means that Nnamdi Kanu has closed his defense and has formally informed the courts about it. When the prosecution opens his case and closes it, calls witnesses, tenders documents, the next thing that follows is for the accused person to also do the same thing that the prosecution did. Call witnesses, testify in your favor, tender documents to tear down the case of the prosecution, right? But in this case, Nnamdi says he has closed his defense and he has formally informed the court that he doesn't have any defense to give to the courts. Number two, it means that Nnamdi has chosen not to speak in his defense. He has chosen not to speak in his defense. Right? Is that a good decision to take? We continue. 3, he has also chosen not to call witnesses to speak in his defense. Nnamdi had listed a number of witnesses. Yes, Onwuke was one of them. The former Attorney General during Buhari's administration was there. And a number of other witnesses, I think 8 or 9 high-profile witnesses, and Nigerians were expecting to hear from them how they are going to testify in Nnamdi Kanu's defense. What happened yesterday means that Nnamdi has informed the court that he's not calling any of those witnesses anymore to speak in his defense. 4, so it means that the court has taken his case to be voluntarily closed by him. That's the consequence, that's the implication of what transpired in court. Nnamdi has closed his case. He's not calling witnesses. He's not also talking in his defense. That's the implication of it. Now, what then happens when a defendant informs the court that he has nothing more to say? Nothing at all to say. What happens? The answer is this.